as exempt employees, and what are some of the options that you have as a business to adapt to those new regulations, particularly how they interplay with the state's regulations on exempt status and minimum salaries, which are different now from the federal requirements. And then finally today, we're going to be talking about another related topic to minimum wage, and that is the local minimum wage ordinances that have been adopted by a number of local government agencies here in Southern California. Just as a precursor, I want to mention there are a number of ordinances that have been adopted elsewhere in the state, in Northern California in particular. I'm not going to be covering those today. I'm going to be focusing on Southern California because most of our clients are here in Southern California. And as you will see as we go through this, even if your business is not domiciled in one of those localities, it still may affect your employees and your business, because employees who do any work within those municipalities or counties are covered by these statutes on minimum wages and paid sick leave. So we'll go into great detail on that at the end of our webinar today. First, before we get to our content, I have to do the obligatory legal disclaimer just to make sure that everybody's clear. Our webinar today is not providing any legal advice or legal opinions. We're really focusing on a concise practical guide and some information on these new regulations regarding minimum wages and exempt status and their potential impact on you. I want to emphasize that every particular situation in employment law, and this is no different, always has some nuances and some facts that impact what kind of advice is appropriate. So if you have particular circumstances at your company regarding exempt employees, for instance, or how this minimum wage or paid sick leave law in, let's say, Pasadena is going to affect your employees, it's always, always advisable to talk to either myself or other legal counsel and get advice on that specific issue. Please don't rely on the general stuff that we're going to be covering here today, because of course the general discussion may be different in specific circumstances. Okay, let's start by talking about what the state of California has done with respect to the minimum wage. As you're probably all aware, Governor Brown signed into legislation earlier this year a minimum wage law that is going to increase the minimum wage throughout the state, and it already has increased it up to $10 an hour. That went into effect in July. And there's a number of different increases that will be going into effect in the coming years. Most quickly is the increase that's scheduled to go into effect on January 1st, which is an increase to $10.50 an hour for employers who have more than 25 employees. There is a delayed schedule under the legislation for smaller employers, employers with 25 employees or less. And I'm going to show you a slide in a couple seconds that shows the difference in the delayed increases for larger employers and smaller employers. But as you'll see when you look at the next slide, there's an increase scheduled every January from here out to 2023 and beyond. So the legislation has a final scheduled increase in 2022 up to $15 an hour, and that's of course in response to the Fight for 15 campaign that has been waged by a number of labor unions throughout the country and including here in California. So in 2023, starting in 2023, there's going to be an annual inflation-adjusted increase to the minimum wage. So we don't know what the minimum wage is going to look like starting in 2023. We do know that through 2022, it's going to gradually increase up to that $15 an hour wage. So here is the minimum wage schedule. Starting in January 2016, obviously we have the $10 an hour already into effect. Starting in January 1st of 2017, for 26 or more employees here in California, that employer has to pay a minimum of $10.50 an hour. But as you see, if you have less than 26, you have 25 or fewer employees, the minimum wage stays at $10 an hour. And then in 2018, January 1st, it'll jump to $11 an hour for those larger employers, and that'll be the first minimum wage increase for the smaller employers up to $10.50. And then in 2019, it jumps an additional dollar for the large employers. For the small employers, it finally reaches $11 an hour. And then as you see, onwards and upwards through 2022, when it hits $15 an hour for the larger employers and $14 an hour for the smaller employers. And finally in 2023, it'll be adjusted upward for those larger employers and at $15 an hour for smaller employers. And then in 2024, both minimum wages will be adjusted based on an index that is contained in the statute that takes into account inflation and other factors. So what does this have to do with exempt employees? As you're probably aware, in order to be considered exempt from overtime and other wage and hour laws, such as lunch periods and rest periods, an exempt employee must make a minimum salary. And that minimum salary is tied to the minimum wage. It's actually 2 times the minimum wage times 2080 hours, which is a full-time year. That gets you to an annual salary based on the current $10 minimum wage of $41,600. So right now, in order to classify an employee as exempt from the overtime and meal and rest period provisions, they have to make at least $41,600 a year. And of course, because the minimum wage is increasing on January 1st, 2017 to $10.50 an hour, that minimum salary goes up. And as you see, it goes up to $43,680. So starting on January 1, in order to classify somebody as exempt under California law, they have to make at least that minimum salary, and then it's going to keep jumping up. $45,760 on January 1st of 2018, and so forth and so on. It will keep jumping until it hits the maximum in 2022, and then from there, we just have to wait and see the adjustments based on inflation. This increase is applicable to all employers. And what I mean by that is that even if you are a small employer that isn't affected by the minimum wage increase going into effect on January 1st, you still have to make sure that anybody you classify as exempt is making that minimum salary of $43,680. You don't get a break because you're a small employer in terms of the exemption. Now, this of course creates wage compression issues, and this is what a lot of employers are struggling with, because if you want to maintain the California exemption, you've got to continually raise salaries for employees who are at that threshold of exempt status, and that's going to create upward pressure on salaries for other exempt employees. And for instance, one issue that you've got to be aware of is under the new Fair Pay Act, you have to make sure that substantially comparable positions are making equal pay between men and women. And if, for instance, you have a male employee who is getting raises due to the minimum salary to maintain his exempt status, you may have a female employee who is non-exempt but is doing substantially the same work, and you may run into fair pay issues between those two substantially comparable positions, even though one's non-exempt and one's exempt. So that's just something to look out for as you raise wages to maintain the exempt status of certain employees under California law. Now things get a little bit trickier. This is where the change to the federal Fair Labor Standards Act in terms of the salary for exempt status starts to impact us here in California. So, as of right now, in order to be considered exempt under the Fair Labor Standards Act, an employee only has to make a salary of $23,660 a year, which is $455 a week. That's the way the feds measure exempt status on a weekly salary basis. So for us in California, this never really was an issue because our minimum salary for exempt status always exceeded the federal standard, much lower, as you can see, than the current state standard. But the Department of Labor, the Federal Department of Labor, issued regulations earlier this year doubling that minimum salary. Essentially, the Fed said, look, we're way behind what should be the minimum salary to be considered exempt across the country, and by regulatory decree, we are going to implement a new standard that essentially doubles that minimum salary. So, effective on December 1st of this year, the minimum salary for federal exemption, in other words, to consider somebody exempt under the federal requirements for overtime, primarily, under the FLSA, the employee has to make $47,476 a year, which equates out to $913 a week. And under the new federal regulations, that minimum will go up every 3 years. So for the next 3 years, it'll be at $47,476, and then 3 years from December of 2016, it's going to go up based on, again, a number of different factors that the federal government will look at tied to inflation, etc. Now, this could have been worse. When the regulations were initially proposed, the Department of Labor actually talked about a minimum salary exceeded $50,000. But when the final regulations came out in April of this year, they actually backed it down a little bit to $47,476. But of course, as you can see, still higher than the state standard. Any questions so far? Don't see any questions in our question box. Very good. So let's talk about how this works under the FLSA now that the exempt salary is going up. One thing I want to mention is that this increase does not apply to certain exempt categories, primarily outside salespeople. So outside salespeople are employees who are working almost 100% of their time on selling a product, selling a service, and they're doing that selling outside of the main workplace. They're going out to the customer and they're doing their sales. So primarily their time is spent outside of the workplace. They are exempt under both federal and state law, no matter what their minimum salary is. Also, the new minimum salaries don't apply to certain professionals. Yes, they carved out us lawyers. We don't have to have a minimum salary under the federal standard in order to be exempt, along with doctors and teachers. Now, that's a little bit different under the state law, but at least under the FLSA, lawyers don't have to make that minimum in order to be exempt. One thing I want to mention, the new salary, if an employee is going to be considered exempt under the FLSA, and they're currently under that threshold of $47,000 and change, that new salary to maintain the exemption must be effective on December 1. So what that means is that December 1 is a Thursday. So you basically have to put that salary in effect at the start of that payroll period so that when Thursday, December 1st rolls around, they are making that minimum. And of course, if an employee is going to be considered exempt under the FLSA, they have to meet all the other exemption requirements, whether that's under the executive exemption, the administrative exemption, or the professional exemption. So they have to primarily spend their time doing exempt duties using independent judgment and discretion. Now, one question that oftentimes comes up is, what effect does this have on part-time exempt employees? Does a part-time exempt employee, can they still be considered exempt if they don't make $47,476 a year? And the answer is yes. Under the federal standard, as I mentioned earlier, their exempt status is based on a weekly salary, and that's true under the state as well. So even though the state doesn't measure it as a weekly salary, you can prorate it. So a part-time employee can still be exempt so long as they're earning at least $913 a week. So for instance, if someone is part-time exempt, they're working 3 days a week, but they're making at least $913 a week, they can be exempt. What you cannot do is say, well, they're only working 3 days a week, so we're going to prorate that salary, so they're going to make less than $913, and we're still going to consider them exempt. That you cannot do. They have to meet that minimum standard. So let's talk about how you synthesize what is the current state standard for minimum salary for exempt status and this new federal minimum standard for salaries. In other words, what if you've got an employee who makes more than $41,600 but less than $47,476? They make more than the state standard, but they make less than the federal standard. That employee would still be exempt in California. So for California purposes, they would not be owed overtime. So that's overtime over 8 hours in a day or overtime over 40 hours in a week. And they would not be required to be offered meal periods or rest periods. So in California, if you've got somebody who's making $42,000 a year, they could still be considered exempt for California purposes. But that employee making $42,000 a year would not be exempt under the Fair Labor Standards Act. So if that exempt employee that you're treating as exempt is working 50 hours a week, that's 10 hours of overtime, and under federal law, you could not treat them as exempt and fail to pay them overtime for that extra 10 hours of work per work week. So somebody could be exempt under California law, but not exempt under the federal standard, and if they're not being paid overtime, they could still sue under federal law for failure to pay overtime under the Fair Labor Standards Act. Now, one differentiating factor between the federal and the state standard that I wanted to mention is that under the federal standard, up to 10% of salary can include bonuses, incentives, and commissions. So, for instance, if you've got somebody whose salary is $45,000 a year, but they're making $3,000 in incentive pay to push them up to $48,000, which would be above the federal standard. That's less than 10% of their salary. The 10% of their salary would be $4,500, and that would qualify them for exemption under the minimum salary standard. Now, that's got to be paid, that bonus, that incentive, that commission, that's got to be paid at least on a quarterly basis. So in other words, you can't count a Christmas bonus at the end of the year as salary for meeting the minimum standard. It's got to be at least quarterly paid. And the other thing, of course, that makes things complicated is that bonuses, incentives, and commissions are not allowed for calculating California salary. So you can count it for the Fed, but you can't count it for the state. So what are our options for dealing with employees that are earning less than the FLSA minimum? You've got this employee who's only earning $45,000 a year, which is less than the federal standard, but it's still more than the California standard. Well, one option is you can, of course, increase their salary up to the federal minimum. You can give them a raise. Obviously, from an employer perspective, that's going to have an economic impact. You're increasing your labor costs, and it depends on how many employees you have in that situation, and that's got to be taken into account. This also can create some wage inequalities, as we talked about earlier. You could raise some Fair Pay Act issues when you give one employee a significant raise in order to get them above the federal standard, and you've got an employee in a substantially comparable job that nevertheless is considered non-exempt, so you don't give them a raise, and now all of a sudden you have an inequality between a male employee and a female employee. So you've got to take that into account when you're deciding whether or not to exercise this option. And of course, you also have the wage compression issue. You give somebody a significant raise, and then other people who are maybe making just a little bit more than that employee who just got the significant raise are going to say, what about me? And of course, in California now, you can't prevent employees from talking about their wages. So you could have a situation where you got an employee who's running around saying, wow, I just got a big raise. Isn't that great? I'm now making $48,000 a year. And other employees could say, well, wait a minute. I've been here 10 years longer, and I'm only making $49,000. Where's my wage raise? So you have to take all of those factors into account in determining whether or not increasing salary is your best bet for meeting this new FLSA minimum standard. Our second option is, of course, you can convert that exempt employee to hourly non-exempt status. In other words, you just say, you know what, we're not going to give this employee a raise. We're just going to bite the bullet and say, for right now, we're going to treat you as an hourly non-exempt. You're not going to be salaried anymore. You're going to be paid on an hourly basis. And I can tell you that is very often an unpopular choice with employees. A lot of people feel that exempt status is something that gives them respect within the organization. It gives them status as a professional, and being converted to an hourly punch-the-clock employee is demeaning. So you've got that issue to overcome with your employees that you're converting. The other issue here is you can oftentimes have difficulty transitioning to timekeeping, particularly with employees who tend to be more higher up in the organization, even though they're maybe not so high up as to justify a salary that exceeds the FLSA minimum. Sometimes what happens is they tend to do a lot of work outside of the workplace. They're on their email, they're on their cell phone, they're handling stuff, you know, in between taking bites of dinner. Well, if they're an hourly non-exempt employee, that's all compensable time. And you have to find a way to track and pay for that time. And that can be a big challenge with converting people to non-exempt status. The other thing you have to look at is if you've got somebody who is currently exempt and you convert them to hourly non-exempt and you're going to pay them overtime over 8 hours in a work day and over 40 hours in a work week, and they're working 55 hours a week, your overtime liability may exceed the salary increase that you could give them to push them above the minimum salary. So you got to look at the economics of it and decide, hey, what's worse? You know, I could end up paying them $60,000 a year because of all the overtime that they work, and it would be easier just to pay them a higher salary. So what are some of our other options for dealing with this? Well, one option is you can convert that employee who's making $45,000 a year to a salaried non-exempt status. And what that means is that even though they are non-exempt, they are not paid on an hourly basis. They earn a fixed salary for a regular 40-hour-a-week schedule. And they would earn overtime for hours worked over 8 in a work day and over 40 in a work week. Now that overtime in California, this is different from the federal standard, and it's a trap for employers. That overtime is calculated based on the regular rate, which is their weekly salary divided by straight time hours worked. It does not include overtime hours. So for instance, if you got somebody who's making $45,000 a year and it's a little under $900 a week, you have to divide that 900 by 40 in order to determine what is their rate of pay for overtime purposes, not by 55 or 60 or however many overtime hours they work during the week. And that leads to a higher regular rate of pay. And then when you pay them, you have to pay them 1.5 times that regular rate of pay for each overtime hour they work. In other words, their salary does not cover the overtime hours that they work. So once again, you may end up in a situation where you're paying more in overtime than you would if you just gave them a salary increase. And of course, you must also track their meal periods and their rest periods, at least offer them rest periods. You don't have to track rest periods, but you have to offer them rest periods because even though they're salaried, they're non-exempt. So that's a very complicated option, but it is an option out there, particularly with employees who maybe don't work a lot of overtime hours. You can still pay them a salary and essentially don't put them in a situation where they feel like they're being treated like an hourly non-exempt employee. Our last options are you could maintain the California exemption and pay overtime over 40 hours in a work week. In other words, you treat them like a California exempt employee, meaning you don't pay them overtime over 8 in a work day, and you don't offer them meal periods and rest periods. And then you just pay them overtime if they work over 40 hours in a work week. Now, what's unclear here, which hasn't been decided either statutorily or by the courts, is whether or not payment of overtime would jeopardize the salary basis for exemption. In other words, in order to be considered exempt, employees have to be paid a fixed salary. If you're paying them overtime, that's going to vary from week to week. You're not paying them a fixed salary. So it may be that the courts ultimately hold that if you pay people overtime and treat them as exempt under California, that violates the salary basis and they were no longer exempt, and you got to go back and pay a whole bunch of overtime and meal and rest periods. And it would also require tracking of hours because you got to determine whether they're working over 40 hours in a work week, which again could jeopardize the salary basis test and jeopardize exemption. So in my view, that option of maintaining the California exemption and paying overtime over 40 hours in a work week is a risky option at this point until we get some more clarity around whether doing so would jeopardize the salary basis for exemption. And our last option is you can just have exempt employees, okay? And even though they're not they don't meet the minimum salary for the federal standards, if they don't work more than 40 hours in a week, it doesn't matter, okay? And in that scenario, if you get somebody who does work 40 hours in a week, or more than 40 hours, or that looks like they're on schedule for more than 40 hours, you just grant them comp time off. In other words, it looks like somebody works 10 hours in one day, and it looks like that would put them over 40 hours in a week. All right, you only have to work 6 hours on Friday. So you avoid them working over 40 hours. You avoid any liability under the FLSA, and you still maintain their exempt status for purposes of California law. So for a lot of employers, that's not going to be feasible because exempt employees, they got to do the job. They got to be ready to go, and sometimes they're going to have to work more hours. But I have run across clients that say, you know what, I got these people who are exempt, but they never work over 40 hours in a week. And if that's the case, then you should be able to manage that and still maintain their exempt status. So just to review, we've got a couple of different options. Probably the most feasible and less risky option from the standpoint of legal liability is just to raise the salary and put them above that FLSA minimum. But you also have the option, of course, to convert them to non-exempt hourly status. And that is probably the second least risky option among this menu. There's a lot of uncertainty about how this would work with treating them as salaried non-exempt or maintaining the California exemption and paying them overtime. And again, until we get more clarity about that, that would be a little more risky from a legal standpoint, choosing one of those options. Okay, let me stop right here and ask if there's any questions about this particular topic with the minimum salaries under the FLSA. So clear as mud, right? It's really unfortunate that the feds have not carved out some sort of state-by-state exception if it's above a certain minimum. That would make things easier in California, but they did not do that. And frankly, we've not had to worry about this for quite some time, but now we do. So it's just a question of adapting and deciding what option is the best option for your business prior to December 1. Okay, so related to all of this, switching gears back from the federal level down through the state level and now to the local level is the various ordinances that have been adopted in the past year by city and counties here in Southern California. And let's start with the granddaddy, the biggie, and that is Los Angeles City and County. Los Angeles City and County have both adopted this year a minimum wage ordinance that applies within the city limits of the city of Los Angeles and in the unincorporated areas of Los Angeles County. So this is an issue that has come up with some of my clients. If you're in the boundaries of a municipality within Los Angeles County, let's say you're within the boundaries of the city of Gardena. You are not in an unincorporated area of Los Angeles County, and therefore this does not apply to you. However, if you're just outside the boundary of Gardena, and it's an unincorporated area, meaning it's not part of any city, then the LA County minimum wage ordinance will apply to you. And as we see up here, this doesn't just apply to employers who have their physical operation within LA city limits or LA County limits. The ordinances, both of them, apply to any employee who works at least 2 hours in a work week within those boundaries. It does not matter where the employer is located or where the employee regularly works or lives. So for instance, you could have an employee who goes out to the customer that's located in Los Angeles, city limits, and works 4 hours at that particular customer, and then they come back to your facility, which is down in Buena Park, outside of LA County, outside of LA City, and works the rest of their day. They worked 4 hours within that particular work week within the city limits of Los Angeles, and that means the LA City ordinance applies to them for that particular work week. So, if you've got employees who are working within those boundaries, even if it's on an irregular basis, you have to make sure, number one, that they're meeting the LA City minimum wage at least for that work. So in other words, going back to our example, you got an employee who goes into the city of Los Angeles during the work week, works one day, 4 hours a day. They're making less than the Los Angeles minimum wage as a regular hourly wage. You've got to make sure that at least for those 4 hours, they're making the Los Angeles minimum wage. And our next slide is going to talk about what those minimum wages are. But I want to make it clear, you don't have to pay them the minimum wage for every hour that they worked, only those hours that they're working within the city or county boundaries. And you also must put up a posting at your locations that's been published by the city or the county where those covered employees work. So you're in Buena Park, you're outside the boundaries of LA City, LA County, but you got that employee who works up in LA, you got to put the posting up. And additionally, LA County says you've got to give notice to the employee at time of hire. So this gets a little bit confusing because how do you know at the time of hire whether that employee is going to be working within the unincorporated areas of LA County? If you're in LA County in an unincorporated area, then you should comply. If you're outside LA County and you know as a regular course of business that employees go to customers within LA County, I would say comply. I wouldn't say give it to every employee. That just seems over the top. And if at some point down the road that employee works in LA County, give it to them at that time. I don't think that's going to create a huge problem. The other thing I want to mention about the LA City and County ordinances is they have a 4-year record retention requirement. So in order to comply with the law, you have to go back 4 years in terms of keeping the hours worked and payroll records necessary to prove compliance. So here's our schedule for LA City and LA County and the minimum wages that have been adopted in those municipalities and the unincorporated areas of LA County. So different from the state minimum wage, their schedule is based on a July 1 implementation date. So no, they didn't go the easy route and try to make everything consistent. No, they decided to go on a different date. So the state minimum wage changes on January 1, but for LA City and County, their minimum wage changes on July 1. And of course, as you see up here on July 1 of this year, their minimum wage went up to $10.50 an hour for, again, larger employers. They did use the same standard, 26 or more workers, $10.50 an hour. For 25 or fewer workers, it's the same as the state minimum wage, $10 an hour. But as you can see, in July 1st, 2017, it jumps significantly. It jumps to $12 an hour for those larger employers, which is significantly higher than what the state minimum wage is going to jump to. It stays at $10.50 for 25 or fewer employers, smaller employers. And then in 2018, it jumps to $13.25 and 12 for smaller employers, $14.25 in 2019, $13.25 for smaller employers. And then in 2020, which is 2 years before the LA minimum, or the California state minimum is scheduled to hit 15, the LA minimum is going to hit 15. And then in 2022, so a full year before the state minimum starts getting adjusted for inflation, the LA county and city minimum is going to get adjusted. So it's in all likelihood that the LA city county minimum is always going to stay ahead of the state minimum because they're going to adjust 1 year earlier than the state. So what LA City also did, and this does not apply to LA County, this is just LA City, is after they passed this minimum wage ordinance, they decided, oh, this isn't good enough. We need to put in a sick leave ordinance. Even though the state has its own sick leave law, we want something different for employees who work in LA City. So effective July 1st of 2016, LA City now requires sick leave for all employees, again, who work at least 2 hours or more within the city limits. So under the LA sick leave ordinance, you accrue 1 hour for every 30 hours worked within the city limits, up to a maximum of 48 hours annually, or you can just grant the employee a lump sum of 48 hours annually. Now, for an employer who is in the city limits, it's probably simpler to grant the 48 hours as a lump sum annually, very similar to the state statute, because accrual can be very tricky and very complicated. Where this gets weird is if you're not within the city limits, but you've got employees who are working on a regular basis within the city limits. Now, if they don't work 30 hours in a year, let's take our employee who goes out to an employer, a customer within the LA city limits and only works 4 hours, and that's the only time he works there during the year. Okay, probably don't have to worry about it because they only accrue 1 hour for every 30 hours worked, and they didn't even hit that 30-hour limit. But if you've got somebody who's regularly going in and out of the city to conduct work, then you're going to have to track those hours to determine when they start accruing sick leave. Now, that's not sick leave on top of the sick leave that you already offer those employees. If you've already got a sick leave plan that meets this standard, then you're okay. Or a PTO plan that meets this standard, then you're okay. But if you've adopted the state minimum, which is, of course, 24 hours in a year, this employee could end up accruing more hours than that 24 hours, and then you've got to pay him or her those additional hours. So it's an extra burden for tracking hours worked within the city limits. Now, under the LA ordinance, unused sick leave can carry over, but the employer can cap that total sick leave accrual at 72 hours. So you got to adopt a policy, if you've got employees that are going in and out of LA, to cap sick leave at 72 hours. Otherwise, they can accrue as much as they want, and that's going to carry over. It's not going to go away. Here's another interesting twist to the LA City Ordinance. Unlike the state statute, the LA City Ordinance says that sick leave can be taken to care for anyone related by blood or affinity that has a close association with the employee. Well, we all know what related by blood means, but affinity? I have an affinity for a lot of my good friends. I could say it's a close association. I need to take time off because my friend is sick. Under the LA statute, that is a permissible use of that sick leave. So the other complicating factor here is if you have an employee who's going in and out of LA and he's accruing more hours than what the state provides, he can use those hours, or she can use those hours on a broader level than on the state statute. So really, to be honest, even more so than under the state statute, under the LA City ordinance, they can take it off for whatever they want. It's essentially vacation. The other difference under the LA City ordinance versus the state ordinance is you can require reasonable documentation for absence, but as we all know, a lot of doctors give out doctor's notes like they're candy, so probably the employee is going to be able to get some doctor's note even if they want to just go skiing with one of their buddies. So that's the LA City sick leave ordinance. If you've got employees working in the city of Los Angeles, even on an intermittent basis, you have to start figuring out how do we track those hours and how do we make sure if the accrual exceeds what we're currently giving them that we give that sick leave to the employee. And you probably should have a policy in place dealing with this. Any questions about the LA City sick leave ordinance? Remember, this is not for LA County, just for the city. So just the city limits. And if you have questions about where the city limits go, I suggest, I believe the city's website has a boundary map. And you can look at that boundary map and figure out where you fall. Okay, a couple of other local ordinances for anybody who's got people working in Santa Monica. Yes, the Santa Monica City Council adopted a minimum wage and sick leave ordinance. It's the same schedule as LA City and County. So if you've got people working in Santa Monica at least 2 hours during a week, again, they're going to have to accrue sick leave, and they could potentially be owed sick leave under Santa Monica, sick leave under LA. It can get really complicated. But again, Santa Monica ordinance requires you to post at work sites where covered employees work. And they also included a sick leave provision. If you've got 26 or more employees, you've got to give 40 hours of sick leave effective January 1st, 2017, and 72 hours of sick leave, which is higher than the LA ordinance, starting in January of 2018. So they, in Santa Monica, are given even a greater level of sick leave than really anybody else here in Southern California. But if you're a smaller employer, you get a break. You only have to give 32 hours of sick leave effective January 1st and 40 hours effective January 1st of 2018. But the state sick leave rules generally apply. So it's the same, take it off for your own sickness, family sickness, etc. So it doesn't have those weird allowances that the LA sick leave ordinance has. For those of you who have employees in Long Beach has adopted a minimum wage ordinance, but I have some good news for you. This minimum wage ordinance is effective in January 2017, and the original version raised the minimum wages faster than the state. The original version looked more like the LA version, but just a couple weeks ago, they had changed the ordinance that they adopted to mirror the state minimum wage increases. So if you're in Long Beach, as long as you're complying with this, you're fine. So that is very good news for employers in Long Beach. And I wanted to mention that in case you've got people working there. Pasadena also has a minimum wage ordinance. This is spreading now. Now if you've got people working in Pasadena more than 2 hours within the city boundary, you've got to post notice, and you also have to give notice to that employee at the time of hire. And their, interestingly enough, minimum wage schedule only goes through 2018. So it's only a 3-year schedule effective July 1. So again, those with 26 or more workers have to go up to 1050, where smaller employers can stay at the state minimum. And then it kind of mirrors the LA City in 2017 and 2018, but that's where it cuts off. So unless they adopt a new ordinance after 2018, it's just going to stay at $13.25 and $12 an hour. And finally, we've got San Diego. San Diego has adopted a minimum wage ordinance that became effective on July 11th. I know, weird day. The reason why that happened is because the ordinance was subject to a vote by the residents of San Diego. And this is San Diego City, not San Diego County. And after the primary election, it took a while for the results to get certified. And once the results were certified, the ordinance went into effect. That's why it went into effect on January 11th. Again, it applies to employees who work 2 hours within the city boundary. So again, if you got somebody going down to San Diego and doing work, or you've got a satellite office down there, it's going to apply to employees who are working within those city limits. Currently, their minimum wage is $10.50 an hour. It's going to increase to $11.50 on January 1st, 2017. This is a different schedule than anybody else. So it goes to $11.50 on January 1st, 2017, and that's for all employers. And then it stays at $11.50 for 2 years and will only increase on January 1st, 2019 based on CPI, Consumer Price Index. And the increases thereafter annually will be tied to the CPI. So we really don't know what the San Diego ordinance is going to look like. If San Diego falls under the state minimum wage, obviously the state minimum wage would prevail. Like some of the other municipalities, you must post a notice and provide notice to an employee at the time of hire if they're going to be performing work within the city of San Diego. San Diego also adopted a sick leave ordinance. So you've got basically 3 municipalities down here who have sick leave: LA City, Santa Monica, and San Diego. Under the San Diego sick leave ordinance, you accrue 1 hour for every 30 hours worked within the city limits, and annual use may be limited to 40 hours of sick leave. Or you may alternatively give 40 hours of sick leave as a lump sum annually. So kind of similar to the state, but a higher level of annual use and a higher level of lump sum sick leave. Unused sick leave under the San Diego statute can be carried over, but accrual can be capped at 80 hours. So again, if you want to cap accrual, you need to adopt a policy that it's capped at 80 hours. Now, what San Diego did, and this is a little bit different, they did put language in there similar to what the state says, that you can use alternative accrual methods if you give greater paid time off. So if you give people 80 hours a year of PTO, for instance, that includes sick leave, you can accrue that at a different rate than 1 hour for every 30 hours worked. So they kind of have a safe harbor that some of the other cities, LA in particular, didn't adopt. And then the rules on use are consistent with the on sick leave. So we've got all these different municipalities. We've got all these different rules that are now being adopted. So you've got the state's got its minimum wage. You've got these different municipalities. How is this going to be enforced? Well, each local ordinance contains provisions that allow employees to complain to that city or county. So each of them has a designated agency that employees can file complaints to, and that local government agency is going to be empowered to require back pays and levy fines. I will tell you that based on what's happened in San Francisco and some of the other municipalities that have adopted these ordinances earlier than down here in Southern California, the local governments become overwhelmed. They're just not staffed to deal with this. So the ordinances also prohibit retaliation against complaining employees. So if an employee comes in and says, hey, I don't think I'm getting paid my minimum wage, and the employer fires that employee, the employee can complain to the local municipal agency, and the local municipal agency is empowered to order that employee to be returned to work. But here's really the kicker of all this. All of these ordinances allow a private right of action. In other words, all of these ordinances allow employees to sue in court based on the municipal or county ordinance. So what you usually see, and what we're beginning to see more and more, is if somebody files a complaint in state court alleging wage and hour violations under the state standards, then they also add in a separate cause of action suing under the local ordinance. So they get 2 bites at the apple. And that is what I would expect to see more and more, is that enterprising plaintiffs lawyers are going to go out and look for opportunities for filing class actions based on these local ordinances. If, for instance, you have a lot of employees who are traveling into these municipalities, and for whatever reason they don't get the minimum wage for the work they perform there, or they don't get the sick leave, then you might be facing a class action, and they'll go after their attorney's fees. So it's not so much the local governments that you have to worry about. It's the attorneys who are going to use this to fuel more lawsuits based on wage and hour violations. And that's why it's so important to know what these provisions are and to adopt policies and practices that make sure that people going in and working in those municipalities are getting paid correctly. Okay, any questions that you have about what we've covered today? I know it's a lot of information. I know given all these overlapping jurisdictions, it can be very confusing. So any questions anybody wants to type in at this time? Probably all of you are thinking, oh my gosh, this is going to be really complicated and confusing. And you're right, it is. So what I would encourage you to do is if you have any questions about any of this afterwards, please feel free to email me. Once again, my email is ebecker@cwlawyers.com. And if you have any questions down the road, feel free to pick up the phone, give me a call. I'll be glad to answer any questions that you have. And also, if you want a copy of this presentation or if you want any further information, please email me afterwards. We really appreciate you attending today's webinar. We thank you for your participation, and please be on the lookout for our email announcing